Welcome to Channel 17, the Town of Colonie Government Channel.
Hello and welcome to The Money Factor. I'm Richard Naylor, your host. Our show today is on business law, but mostly connected to small businesses and legal issues. Our guests are Stuart, Klein, and Frank Mayer from Bond, Schoeneck King. I want to thank you very much for taking time out to come and visit us.
Our pleasure. Thank you for inviting us.
Thank you, Richard. It's nice to be here.
We haven't had a show on legal issues for small business. We've gone over financing and things like that, but this is the first, so it should be good. It's hard to know where to start, but I think your firm is large, varied, has a lot of skills. I think it would be good just to give a little bit of background on it to start with.
Sure. Well, Bond, Schoeneck King is a law firm of nearly 200 lawyers. We have 12 offices, many of which are in principal cities of New York State, including an office in Albany with about 29 lawyers at the moment. But we have attorneys in many different practice areas: business, litigation, tax, intellectual property, employee benefits, virtually every area of the law we have attorneys practicing in.
And I noticed that just about everything you said has to do with business, and I think that's the reason why you're not a household name, because you're not going to pick up the murder trial or the things like that. You're really specializing in business insurance.
We do a lot of business, insurance, labor work, litigation, that type of work.
Not the Perry Mason type, but a really important type.
Important type to our clients, yes.
So what kind of things do you do, especially locally? What are some of the most frequent things that you deal with?
Well, I think it runs the gamut depending upon the type of work that you do. As Frank's mentioned, the attorneys in our office specialize in a variety of different things. I myself am a litigation attorney, or what's more commonly referred to as a trial lawyer. So the cases that I typically deal with are the ones that end up in dispute in a court in the state of New York, whether it's a local Supreme Court, which is the trial level court in New York. New York kind of has it opposite from the federal government. The Supreme Court is our lowest level of court.
I didn't even know that.
So you learn new facts every single day. And our highest court is the New York Court of Appeals, which you would think that the Supreme Court would be the highest court and the Court of Appeals would be a lower court, but it's reversed in New York. But or there's cases that are in federal court, and the district that we sit in Albany is the Northern District of New York.
Okay.
So if there's a lawsuit in a local Supreme Court, I would handle those matters, or in a federal district court in New York, which the local district is the Northern District of New York, which sits in Albany, Syracuse, and Binghamton. There are various courts there. But the types of work that I do run the gamut. They all tend to have a business core, so to speak. There tends to be a dispute between two businesses where it has ended up in litigation.
So we've heard of business to business, but this is business against business.
This is business against business, and the ultimate goal is to try, absent having to try the matter, is to see if there's a way to amicably resolve the situation without having to go to trial, where somebody is proven to be the winner and someone is proven to be the loser. I think the ideal situation is where the businesses can work out a happy medium for everyone.
Right. And do you also see that kind of client as well, the same type of problems, or?
Well, I see business-to-business transactions as opposed to litigation.
Okay.
Business-to-business transactions usually mean that parties come together and they want to do something. What do they want to do? One person wants to buy a business, another person wants to sell his or her business, or the parties want to get together and prepare a business contract. Perhaps it's a licensing and distribution agreement, maybe it's an employment agreement or some sort of administrative service agreement. So usually it's businesses come together to work together as opposed to being in opposition to one another when cases are being litigated.
So perfect complement here.
They are a perfect complement. And taking an example that Frank mentioned, say there's a business that wants to acquire another business. Frank may work with one of those businesses to work on the acquisition of that entity. Now, say 3 years later, there's a dispute between the acquired business and the new company, and they're of the position that when I acquired this business, I also acquired some goodwill from you, and I acquired your services to work for me for X number of years, and there's a disagreement. That may end up in litigation, so it shows how it kind of all comes full circle, so to speak.
That's interesting.
Another example of that might be, is to add to what Stuart just said, is let's say that the seller might sign a non-compete agreement with the buyer. In other words, that the seller won't open up a business across the street and do exactly the same thing, which would substantially diminish the value of the purchased goodwill that the buyer just acquired. That's the time that Stuart would come into action and perhaps litigate the matter.
So instead of saying it's not fair, somebody might be able to say it's not legal because you signed this
non-compete agreement. Right, because when you buy a business, what you often buy is the going concern value of a business. In other words, you could buy a business which might be a few cash registers and some shelves and some inventory, but a buyer typically pays for much more. The buyer pays for the goodwill, the workforce in place, the customer lists, and so forth. Those aren't tangible assets that you could actually sell, and the value is only there as
what
a
somebody
going
would
concern.
pay for it, right?
And if suddenly the seller is open to business across the street with substantially the same name, where is that purchased goodwill? The buyer paid a substantial amount of money for some cash registers, some shelves, and some inventory.
Right. So that's pretty interesting too. It's an interesting, not really a contradiction, but as we said, complementary. I think most of the people probably watching fall into a group that don't have problems, because if they did, they'd already be seeing you. But I think it's an interesting question. On your website, you talk about don't wait until you have a problem. Come see us, make plans, take care of situations. So if you do come see us, you'll have a better case, and maybe you won't even have to come see us.
You know, the best situation is when a client, an existing client or a prospective client comes into our office and says, I want to enter into an agreement with this third party. Then we have a lot of opportunity to work with that person. Perhaps the other party has provided with our client or prospective client with a draft of a document. It allows us to work through it and point out the good points and the points that are not so good for this client or prospective client. The most difficult or most challenging situation for us is when a client or prospective client comes into the office and says, I've already signed this agreement. Can you tell me what's wrong with it?
And that's what happens. A lot of times that happens with the small business owner is that they may be shown a variety of documents and asked to sign here and sign here and sign here, and relying upon the representations made by the larger company, or the big box store, so to speak, and say just sign here, sign here, sign here. Don't worry about it.
It's all just a formula.
It's all just a formality. And then they take the individual at their word. They sign those documents, and then somewhere along the line, the big business is trying to go after the small business and say, well, when you signed this document, you agreed not to do X, Y, and Z. Now you're doing it. And as Frank said, a lot of times it would be a lot better when the entity would come and say, this company I'm dealing with has asked me to sign these documents. What do you think about them? This is what I plan on doing in the future. If I do sign these documents, will I be able to do that? So you're in the active negotiation stage, as opposed to if it's already ended up in dispute, you're kind of left with those documents, and you have to think of creative ways to potentially undo something that may have unknowingly been done.
And it might be difficult.
And it may be difficult, yes.
It's almost always more difficult and more costly to try to undo a transaction than to have the information in hand up front before the documents are executed.
Yeah, and it's just so logical. But I think that the problem a lot of people face is it's harder, it costs money, let's just get to it. I really didn't want to start this business so that I could become a lawyer. I really just want to sell this, or
sure.
I'm excited about my product.
And that's the concern. Many business owners, startups are very bright and talented people. They know their product line, or the service that they provide, but sometimes the details, if you will, are let go, and they may not pay attention. It's like, well, this looks like a boilerplate contract. I'll just sign it, and maybe I'll show it to my lawyer at some point. And oftentimes, they show it to their lawyer when they get a notice or demand or something in the mail that says you didn't comply with the contract, and then the business owner will say, well, gee, I never agreed to that.
And then there's nothing that you can undo to change the mindset of somebody who is of the feeling that, well, I don't need a lawyer until there's a problem. I mean, you can only impress upon them that there's certain things that they can do to be proactive, to try to better themselves. I mean, in the ideal world, everybody would go to the doctor when they were feeling sick, and in the ideal world, everyone would go to a lawyer before starting up a business to make sure that they're forming the right entity, and they would go to their accountant and things of that nature. But that doesn't happen. I mean,
Right.
But all that we can do is to some extent is recommend and provide certain guidance as to things that small business owners can do to proactively protect themselves. So if they are in trouble, or if there is a problem that arises down the line, they've done enough at the beginning to potentially minimize any potential exposure to themselves and their families.
Well, let's touch on a few areas. I know with a half-hour show, you can't do an 8-hour workshop. But the purpose here is, and you've come to help, is to give people some ideas, at least areas where they should be careful. And we thought we would start with just talking for the person who's thinking of starting a business. I know, again, it's way too complicated to give a lot of details, but at least to know a little bit about options. Types of business. Should I go in business with my brother-in-law? Should I have an LLC or a Chapter S, or
Sure.
what do you do?
Well, I guess it's okay to go into business with your brother-in-law as long as you have an arm's length relationship with your brother-in-law. In other words, you treat your brother-in-law just as you would treat any other prospective partner or shareholder in a business venture.
And be able to do that emotionally.
Right, with the proper emotional detachment. But I think, Richard, you raised one of the important threshold questions for a new business owner who often start with an idea, some capital, and some fixed assets is, do I want to put these assets and this business into some sort of corporate solution? In other words, do I want to form an entity? And if so, what entity do I form? Now, why would I want to form an entity? Well, a number of the entities that a person would form give the business owner the advantage of limited liability, meaning that the individual is only liable for his investment or her investment in the business. In other words, if something goes wrong, only the assets of the entity, be it the corporation or the limited liability company, are at risk, not the individual's home and automobile and college savings accounts and
Right.
so forth. So that's something important to address up front. In addition to that, the business should be capitalized with adequate insurance as well. But there are a number of different types of business entities that an individual could form. There's the corporation, which can be organized as either a subchapter C corporation or the S corporation. The big advantage of the S corporation is that it's only taxed at one level. In other words, the corporation pays no tax at the entity level, but instead the earnings and profits of the corporation are passed through to the shareholder or shareholders who pay tax on a pro rata basis.
Now, in a way, that's what business people have been, and stockholders have been asking for as long as I can remember.
Business people and stockholders have been asking for that treatment for C corporations. For example, a large Fortune 500 corporations are virtually all C corporations because an S corporation has a limitation of 100 or fewer shareholders. You can't have multiple classes of stock. You can't be a non-resident alien shareholder. So for many of these reasons, larger corporations tend to be organized as C corporations. The disadvantage of which is that the entity pays tax at the corporate level, and then when you as a shareholder receive a dividend, you again pay a tax on that. So 2 levels of taxation, and the effective tax rate can be quite high, which is why many businesses often select sub-S status when they're able to do so.
So it seems like unless you're planning on being McDonald's, although that's a little bigger than the 100 employees, if you're planning to really grow, you might worry about this decision. But for a lot of people, it would seem simple to start with an S.
With an S corporation, or a limited liability company. Now, limited liability companies are becoming increasingly popular. The limited liability company is a relatively new concept in law. It first appeared in Wyoming in 1977, and since then, all 50 states now have limited liability statutes, and New York passed its limited liability statutes in 1994. Now, the great thing about a limited liability company is that it gives you the limited liability protection of a corporation, but the freedom to structure the transaction that a partnership would give you. So it's really the best of both worlds, and in many cases is the best solution for a small business owner, because you can allocate profits and losses differently between members of the LLC. In LLC, the owners are called members, not shareholders.
Okay.
An LLC is taxed as a partnership for tax purposes, which is somewhat similar to an S corp in that the earnings are not taxed at the entity level. The entity is considered a tax transparent entity. Instead, the earnings pass through to the shareholders, and they pay tax based on the earnings that are distributed to them.
And that's a LLC?
That's an LLC.
Okay.
So it's a little bit similar to the S corp. The big advantage of the LLC is that you can allocate profits and losses differently than the S corp, where you really pay
Could you
tax.
give one example of how you could allocate the profits differently?
You might allocate, if let's say you buy a building, you might want to allocate the depreciation expense on the building to one member of the LLC, but not to the others. Or
okay.
you might want to allocate profits differently if somebody makes a big investment in the LLC until that person recoups their investment.
Gotcha.
So there is a lot of flexibility. This downside of an LLC is that all of the income, or virtually all the income of the LLC, is subject to self-employment tax. In other words,
so you don't write off as much for...
Well, the self-employment tax, in other words, the employer and employee share of Medicare, which is not capped, so it's 2.9%, which is a big chunk of money. Now, the S corporation, the shareholders can work for the business, set reasonable salaries, and then the money that comes out in excess of reasonable compensation isn't subject to this self-employment tax of 2.9%. Now, you can't set your salaries at $5,000. The IRS doesn't like that. But you can set reasonable compensation, and then any amounts earned beyond that would just be taxed as dividends income, not as wages, which are subject to higher tax rates because of the self-employment tax issue.
It sounds to me like this is complicated enough that a person should get some advice.
It is. It's worth sitting down with your tax advisor to kind of work through your particular situation. I'd like to say that one size fits all, but that's not always the case.
And I think, especially one thing that Frank mentioned is, and I think you mentioned, Richard, too, is that business formation is something that's very important. I think it's also something that needs to be reconsidered as a small business grows. I mean, what may be the best business formation today for a small business may not be the best formation for that business 2 years from now, when maybe they've grown in size.
I was wondering, you can change.
Well, you can change, but let me say this. A corporation is a lot like, a professor of mine once said that a corporation is a lot like the treadles in a parking lot, meaning it's very easy to get in, but it's very difficult to get out.
Oh, those nasty things with the points on? Yeah.
What I mean is that when you take money out of corporate solution, it can typically trigger a taxable event on any appreciated property that comes out. So but not so necessarily with a limited liability company. So it's easier to convert a limited liability company to a corporation on a tax-free basis than to attempt to do so in the other direction, to transfer money out of corporate solution into a limited liability company. I just want to say that.
But it might be then okay to start as a LLC and move to a corporation
if it's determined that that's the right thing to do.
Of course. Right.
Because one thing I think you need to do as a small business is constantly, evaluate yourself and where you are. I mean, the direction that you may be on the day of formation may be totally different than where you may be 10 years from now. For example, one of the other things that Frank mentioned is proper insurance. And I think the way that we see things is there's two fundamental things that a small business owner needs to consider. One is the type of corporation that it is or should be, and the second is, does it have the right amount of insurance and the right type of insurance? Take, for example, a small business that plans on selling a a widget, a hypothetical product, so to speak, and they plan on renting a warehouse space. So what they do is that they get renter's insurance, they get business income insurance, they get workers' compensation insurance, they get an umbrella policy, they get liability insurance, and 3 years from now, the business has totally changed its focus. You may be in a situation where the business is overinsured for what it's doing. So they may be paying X number of dollars more a year than what they need insurance coverage for. Complete opposite.
And perhaps your current company is not going to be the first one to tell you that you're paying too much.
Oh, no, not at all. I mean, there would be no, I think, to some extent, if you're continuing to pay your premiums and things of that nature, it's good for the company that's getting that money.
Right.
But the reverse situation also is the case. Say, for example, you start off very small, and all of a sudden your company mushrooms, and now you're renting space. And when you originally started your business, you didn't have rental insurance. Now you're making a product in your specific facility, and there's a fire, and you fail to get a business income policy, which would allow you in certain situations, if there's a catastrophic event, to maybe recoup some lost profits as a result of that event. You didn't do that at the beginning. Those are certain things, and now you're underinsured. So you need to make sure that you constantly kind of reevaluate yourself to make sure that does the coverage, we'll use the term coverage for insurance, is the coverage that I have right now enough for what my business has developed into, or is it too much?
Sounds like a portfolio management.
Exactly, and I think a lot of times people are very comfortable with, well, I got this, I got that, and then when the bill comes in the mail at the end of the year or whatever their premiums are due, they just pay it, when in reality they fail to consider, do I really need this? And for a small business, you may be paying money in insurance premiums for policies that you don't need, or the complete opposite, you're not paying for policies that could cover you in the event of a problem. And
Which is a double loss now.
Exactly, and people don't like to think about, well, what if there's a fire, or what if there's an accident on my premises, or what if one of my managers is accused of harassment. They don't want to think about these things that potentially that there could be insurance coverage for.
Well, because there's so much pressure every day on what's going on just running the business. It's hard to think ahead.
And like Frank said, is that a lot of times people who start a small business are so focused on their product that they're not concerned about the risk management side of things. And that's sometimes things with the simple paying of a few $100s a year for some form of insurance may cover them in case someone falls on their premises. It's just the being proactive is tough to kind of impress upon people.
I think that's the case in so many things, that people don't invest enough for their retirement because we're having a hard time feeding ourselves right now, for example. And yet we see what people pay for restaurants, and that can add up to a lot of money over a year. So yeah, it sounds like really good advice. Are those the two biggest things then, insurance and the type of company? So those
are really good starting points.
One would be major for if you're just starting out.
Yes.
You need to know who you are. And the other one is going to be ongoing. As you point out, it's even more ongoing perhaps because insurance could change faster.
Yeah, I mean, your policies typically get renewed every year, and you can adjust your policy amounts and things of that nature. I think another
routinely, really.
Routinely, yeah. I think another thing that is very important, and I think Frank will attest to this as well, is, and this is something very, very basic. It's the simple concept of documentation. A lot of times, individuals are so concerned about the product or getting their company up and running that they're less concerned about just normal paper keeping, as far as invoices, receipts, bills, things of that nature. They just tend to pile up, and people lose sight of the fact that those documents are, to some extent,
they are part of the record.
They are part of the record, exactly.
And that includes emails.
That includes emails as well. And I mean, for example, you may a company may be dealing with a distributor for something that they are manufacturing, and they have one of the key elements is that the price has been negotiated for this product. and the small business owner calls up the distributor and says, "Do you think you can give me a deal for these products? Charge me, 10 cents a piece as opposed to the 15 cents a piece." And the person says, "Sure, no problem." Yet the small business owner could follow that up with a written letter confirming, or a quick email. Yet they choose to just take the person at its word, and then they get the bill, and that 15 cents over 10,000 units works out to be a big dollar amount, when something simple as a quick follow-up letter documenting that could have saved them a lot of problems.
Because now they have no fallback to say, look, you said it was going to cost this much. Here's my check.
It's he said, or she said, she said. And it's always better to have a contemporaneous record as to what transpired.
One of the most difficult things, I think Stuart will agree, particularly in the litigation area, is trying to reconstruct records when a case comes in. If you ask two litigants to tell their side of the story, it sounds like two completely different cases. And the documentation is really important, and it helps the attorney. It keeps the legal fees more reasonable if the record is in place.
You want to be able to walk up and say, well, according to this thing that you just signed, it says this.
Exactly.
Or the email that you sent me on this date, which I replied and acknowledged my acceptance.
Now, how do you prove that an email is really something that was received?
Well,
sent, I guess.
One thing that I tend to do, and just kind of in a common practice that I do, is when I send an email to somebody, a lot of times I CC myself, just so I have, other than having to go into the sent items box, which may automatically delete from some people's computers, I have a record that, look, I sent this email on this date to Richard, and this is what it said, and it also went to me. So it's kind of, proof, so to speak. So if you don't have the copy of the email and you lost it, you can say, look, I have maintained a copy of this document.
Or you may set up sub-files or something like that, but whatever works best for you and your IT department to kind of memorialize this stuff.
Now, what makes that official? Are we pretty much accepting an email today? If you show a judge a copy of an email, they'll believe that you didn't create this?
I think that there's a lot of layers to that question, so to speak. But typically, what you would want to be able to establish is that that's a document that was routinely and customarily sent by you in your business, that there's some parameters, that it is an authentic document. If you're going to trial and you need to get before a judge, then I think the problem is a lot bigger than you expected it to be. But ultimately, your goal would be is when you speak to that distributor where he agreed to provide you the widgets for 10 cents a piece, you can say, I know you don't have any recollection, but here's a copy of the email. So it's more of a negotiation tool than as opposed to admissibility of the email at trial, which is where
much more difficult
to establish.
Could we go into that just a little more in terms of, there are a lot of documents flying back and forth, and if somebody is concerned that this order is a fake or something that somebody says I bought this and they show something, how can you be sure that you're doing all you can to, to produce a document that would be considered official?
Well, there are authentic documents. There's no question about it that certain documents are the authentic ones, whether they have the notary stamp on them, or if they're the carbon copy documents where the white goes to the customer and the yellow stays with the merchant. A lot of times, however, in litigation, the originals aren't around anymore because
photocopy.
Exactly, you have the photocopy that you maintained in your file as the small business, and the big business
They've got multi-colors.
But conveniently doesn't have the original document. You would need to establish that this was your company's practice and procedure, that you would send out originals, that is your custom and practice, that you would maintain a copy, that there's someone who can attest to the fact that on this day, at this time, I sent this document out, so that you would be in a situation where, though you may not have the quote-unquote original document, you can establish that the copy that you have is an authentic copy and that it was actually sent to the other side. But those are usually situations that only happen at trial as opposed to in negotiation.
We're getting close to not even having any more time left, and we barely covered just the essentials. The most common situations. I was interested also, are there any issues with business failure? Should you set up some kind of system so that should you fail, there's an exit strategy?
Well, I think in structuring a business, one considers the possibility that the business may not succeed by forming a limited liability entity so that only those assets, we mentioned earlier, only those assets that are invested in the business are at risk. Now, one thing a business owner has to be careful of, and I've seen this a number of times, is that a bank or another party loaning money to the small business owner will often ask for a personal guarantee. In other words, a corporation may borrow money, but the individual will sign and guarantee that loan personally. So if the corporation fails, the individual agrees to pay that money with his or her own resources.
So they've kind of contravened the structure of their company.
Exactly. In other words, they've compromised that limited liability shield. And many lenders, are wise enough to ask for that because it would be too easy to form a limited liability entity, drain off some of the assets, and then not repay the indebtedness.
And that brings us back to maybe the final area, and then I'll ask you if you've got any last suggestions for people. Dealing with a large company, we spoke about this a little bit before the show. If I'm running a kiosk or a barbershop or a restaurant even, and a really large company has an interaction with me, they're going to have a staff of lawyers, and they could stall and things could get dragged on, and I might not be able to afford that. What do you tell a small business? How can they protect themselves a little bit from the fact that they're small, they don't have the resources to defend themselves?
I mean, I think just because an entity doesn't have the resources doesn't mean that they can't be diligent or they can't ask questions. I mean, there's nothing preventing the small business that when this big company comes and tries to pressure them, if they have concerns, to voice those concerns. If they're concerned about how this agreement may impact their kiosk space and whether or not they have to sign an extended lease for that space and commit a certain amount of dollars to the big company to rent the kiosk, put that in writing. Have them submit their questions to the big business. They may not give you, whether or not they give an answer is one other thing, but
if they don't, that might tell you something.
It may tell you something as well. I mean, like I said before, document everything. I mean, you want to maintain the best possible paper file that you can, because a lot of times smaller businesses may have better records than bigger businesses because they have so much paper.
Sure.
Mm-hmm.
So you want to be able to put yourself in a situation where if there's a problem X number of years down the line, you go look in your file and you say, 2008 communications with Richard Naylor, and you just go in your correspondence file. And that way you have everything. And when the person from the big business speaks to the small business and says, well, do you remember when you did X, Y, and Z? You can say, no, well, I think you're mistaken. It actually happened like this. And would you like to see the email or the letter that I sent to you memorializing that?
And then,
Exactly.
And I think, many lawyers understand that small businesses, like you're describing, have limited resources, and a lot of times a contract may be presented from a large business to the small business, but it may not be too costly, and certainly not in the long run, for the small business owner to spend an hour or two with their lawyer to just sit there and have the lawyer read through it or answer questions about sections of the document, point things out, and then you may not need to get the lawyer involved with the big business, but you could at least give the small business owner, arm that person with the questions he should ask or the things that he should be looking for.
And maybe some red flags.
Red flags, and allow that person to go back to the big business. You haven't spent a great deal of lawyer time on that, but you've probably headed off most of the problems, hopefully at a modest cost.
Sounds good. Any final advice for people?
Well, I guess if you are going to undertake a business venture, speak to your counsel before you sign, not after. And even if it's coming in to spend an hour or a half an hour with the attorney and just talk about what you're going to do, I think it can save a lot of difficulty and concern down the road.
Sounds pretty good.
Yes, I agree with Frank. I mean, you want to be careful. You want to take your time. If you're willing to undertake the endeavor of starting a business and spending quite a bit of time and resources, Whether it's your tax advisor, your lawyer, or someone, your business advisor, take the necessary time to protect yourselves. I mean, what a few $100s or a few hours of your time could potentially save you, thousands in the long run. So, better safe than sorry.
Sounds good. Stuart, Frank, I want to thank you both.
Richard,
Thank
it
you
was a
very
pleasure
much.
to be here today.
Great.
Our pleasure.
And I want to thank you for watching and hope you enjoyed the show. See you again next time, and take care.